My name is Jeff Weiss, and I'm an attorney at Bond, Schoeneck King. Welcome. We're here for the Spring 2024 Special Education Update. Many thanks again for all of you for coming out. We know everybody's so busy this morning. We have a great program today. We have a lot. We always say at these programs, it's all about substance. So we have 2.5 hours of jam-packed, fun information for you to take back to your schools. So I want to go over the agenda for today. We're going to be here for 2.5 hours. We have 4 fantastic topics. The first topic is we're going to speak on the latest on restraint, seclusion, and timeout, everybody's favorite topics. And we presented on this topic in the fall, but there's been a lot of changes since then and more information. It's such an important topic. We're going to give the latest and greatest on that information. Then, after that, we're going to have a program presentation on how to run a legally compliant manifestation determination review meeting so we can get ready for more suspensions for the rest of the year as everybody's excited. Then we're going to take a break at that point, and then we're going to have 2 very important topics. First, we're going to talk about some classification dilemmas with everybody's 2 favorite classification categories. It's emotional disability and other health impairment. And there's a lot of legal issues sprouting off those 2 classifications. And then we are going to finish it up with parental consent. Lots and lots of nuances surrounding parental consent. So as we always say, we want these programs to help you do your jobs as special ed administrators. So that's what we're here for today. So want to introduce, well, the presenters, obviously I'll be presenting, and the other presenters will be my colleague, Andrew Mark, Ann McGinnis, who's now, you used to call her Dr. Ann McGinnis. Now I can call her Mom. So, okay. And also, we have a very special guest from downstate, Candice Gomez, who is the co-leader of our school group, and she came up all the way from Long Island for this. We thank you so much for that. And you all know Tracy Laparty, my partner in the Bond, Schoeneck King office in Buffalo. So thanks again for coming out to the program. And again, kind of get a flavor for, obviously, last time we were here, we were at a different law firm, and so we made the move to Bond, Schoeneck King, and there's a lot of depth here, as you could see from Candice coming up from Long Island. It's a much bigger group. We have maybe 25 school law attorneys from around the state, so we're very grateful that Candice is coming up here today, sharing her expertise and knowledge with us. So a few more things. I will get criticized if I don't tell you that there is Wi-Fi here. If you're looking for Wi-Fi, look up Chateau. Pretty fancy, right? Chateau. And the password is Creekside1. So if you need some free Wi-Fi, link on in. And again, we also have people, lots of people have signed up for this remotely. So you're going to see at times when we're asking questions, and we're going to take questions from the audience, we're going to come around with a microphone for you. Because we want the people who are accessing this program remotely to hear the questions. So that's about it. So enough of me. Let's get right into the program. Andrew, you're up first, so take it away.
Can everybody hear me? Okay, great. I thought Jeff was going to tell more jokes. I'm not ready. Yeah, I know. They're like waiting for it. Okay, well, I'll tell you one. So just kidding. So the only thing funny that I can share with you is that this morning my daughter, who's 6, said, "Why is the sun a thing?" Like the sun in the sky. So we got to talking about the Big Bang, and I probably just should have said, "I don't know." And then my son said, he's 3, he said, "When I grow up, I want to be Michael Jackson." So that was fun. Anyway, I don't know if that's possible, buddy. But anyway. So, all right, I am here to talk about the latest on restraint, seclusion, and timeout. Actually, for the most part, we're going to be talking about timeouts and physical restraints. Those are the biggies. We've talked about this before. We had an extensive presentation on this in the fall after the new regulations came out in August. There has since been some new guidance memos issued, so we wanted to make sure that we address those and point those out. If for those of you who aren't aware, be able to direct you to those and talk about a few pieces of information that are in there because I think they answer some questions that have come up. So, since we've talked about this before, we're not going to do everything that's included in the regs, but we are going to do some of the old as well as some of the new, just so we have the proper context. Okay, so in a nutshell, this is the regulation 19.5, came out in August, as I mentioned. It applies to all these entities, so public schools, charter schools, BOCES, just about everybody. I'm not sure even who's not included in that. All right, so in summary, this is what it does. So it prohibits corporal punishment, reversive interventions, and mechanical restraints, prohibits prone restraint. That was new. It amended the requirements regarding the use of timeouts and physical restraints, or what used to be called emergency interventions, and added additional requirements. For example, to have policy, documentation requirements, debriefing requirements, parent notification, and reporting requirements. And that's one of the things that is in the memo. We have this new reporting requirement. Got a lot of questions about that. So we'll maybe not be able to answer every question you have, but we'll certainly talk about it. Okay, and as I mentioned, so since August, SED has released 2 guidance memos. Okay, the first one was the reporting requirement, a memo addressing the reporting requirements. That came out in November. So there's the title, Reporting Student Behavioral Interventions. That starts next school year. And then there was an FAQ document that was released in January that addresses some of the common questions that were on people's mind. In many cases, as often as the case with some of these guidance memos, you get a recitation of what the regulations are and not really a lot of detail and explanation. And so we'll have to parse through that. Now, what I just learned last night, and I don't feel so bad because I talked to one of my colleagues and they didn't know this either, but about 2 weeks ago, the January guidance was updated. So about April 22nd. So I don't know if any of you were aware of that, but I just learned that last night. So we're going to talk about some of the things that are included in that update, that sneaky update that they just snuck out there. But some good information. So this is brand new stuff. Okay, so just to get a little background, we'll do the definition. So a physical restraint, as we know, is a personal restriction that immobilizes or reduces a student's ability to move their arms, legs, body, or head freely. It does not include a physical escort, which is, a temporary touching or holding. We're guiding a student down to maybe de-escalate. And then a prone restraint is a physical or mechanical restraint while the student is in the face down position. Okay, so these are the definitions. This is what we're talking about. So in the January 2024 guidance addresses a situation, not every situation is the same, okay? In schools, you have lots of situations come up. You might be escorting a student down the hall and they're still agitated. I know when I was teaching, this would happen frequently. You break up a fight, student is still heated, okay? And it doesn't just always break up the fight and then they go and calm down. Sometimes things happen as you're escorting them. So if you're physically escorting and then you find yourself having to, briefly immobilize that student, okay, that could be a separate incident. All right, so there are scenarios in which where a physical escort could turn into a physical restraint, in which case that would be a documented event. So just something to be aware of. Now, where's the line? I mean, how long do you need to be holding a student for it to not count anymore as a physical escort? Guidance doesn't really address that. Okay, so we'll need to be answering those questions on a case-by-case basis as they arise. Okay, timeout. The definition in the regulations, it's a behavior management technique and it involves a monitored separation of a student in a non-locked setting that is implemented for the purpose of de-escalating, regaining control, and preparing the student to meet expectations to return to their education program. And that's a little bit of the old language, de-escalating and regaining control. It's importantly under the regs, it has to be used in conjunction with a behavioral intervention plan. The exception to that is situations that create an immediate concern for the physical safety of the student or others. So if there's immediate concern for the physical safety, that's an exception. What's an immediate concern? That is kind of left up to the person. That's why the training becomes important. That's a little bit subjective. We'll talk about that. So importantly, the regs say the staff shall return the student back to their program once they're prepared to meet expectations. So they must be returned to their educational program as soon as they have safely de-escalated. We'll talk about a question that comes up often, because we have those students who, they come down to the counseling center or something, and we know that if they return back to their classroom, we've heard these stories, we've gotten these questions, and we know that if they go back down to the classroom, things might escalate again. What do you do in that situation? All right, timeout is not a student-initiated break. It's not a calming space. We used to get this question a lot before these regs came out. So use of a space containing tools or activities to assist the student to calm, all right, a calming space. And it's not a teacher removal, an in-school suspension, or any other appropriate disciplinary action. So when we think of a teacher removal, we might think of a teacher just saying, please leave. Okay, that's not what that is. There's a little used section, disciplinary tool where a teacher can actually remove the student from a classroom, I think for up to 2 days. But it's a disciplinary thing that under the statute. It's not what we're talking about here. An in-school suspension is not a timeout. We've had questions about when does a timeout become an in-school suspension. That's a little, we could talk about that, but there are different purposes behind a timeout and an in-school suspension. Like an in-school suspension is a disciplinary thing. Okay, a timeout is to remove the student so they can safely de-escalate and regain control. So the intention is important when we look at those two things. Okay, so SED came out with, like I said, the guidance in January addressed calming spaces. So first of all, must never be locked. We know that has to be in a non-locked setting. And cannot be used or strictly isolate the student as a form of punishment. All right, the intention is that the use is temporary. It's a temporary intervention strategy, and students must return to the class as soon as they are able, ready to learn and missing as little instruction as possible. So, we see this movement from SED, not just in this universe, but in disciplinary classroom removals in general. There's a push towards restorative practices and not exclusionary discipline. We don't want to take students and remove them from instruction. So same idea here. The guidance says that we should be monitoring the use of this strategy. There is a I'm sorry, I'm blending timeouts and the use of calming spaces. So we want to be monitoring the use of this strategy. Routine or more frequent use of this strategy may warrant a functional behavioral assessment. So if this is happening, fairly often, and we don't have a student with a behavioral intervention plan, maybe that's something we want to be looking at. Okay, so the temporary nature of this, a question we get is sometimes, like I mentioned, you have students who need to be in the counseling center all day, and if they return to class, it's not going to be good. So two things, if it's not being used consistent with a behavioral intervention plan, the limitation is a timeout can only be used if there's an immediate concern for physical safety. So it doesn't necessarily contemplate a disruption to class, okay? If there's an immediate concern for the physical safety, I think that's something important to keep in mind. Now, you might have a student that's acting aggressively, and maybe that's a concern for the physical safety. But, we can't, I think, just in general, I think SED, it's clear SED is pushing for us to be using less restrictive techniques and more proactive and positive approaches to keep the students in class. So we might have teachers who just have that hair trigger and want to remove a class and might not be able to continue doing that. The second thing to keep in mind is, we have to report these incidences. And one of the reporting requirements is you have to report the duration of the intervention. So how long was the timeout? So if you have a timeout that's all day long, that's going to have to be reported. Now, you might have to, I'm not saying you can't do that, but it is something to keep in mind. And I think, SED is clearly emphasizing that other less restrictive techniques should be used. So just keep those two things in mind. If you have a student in timeout all day, that's got to be reported, and probably not a great look. Not saying you can't do it, but the other thing also is, keep in mind that it's to be used if you have an immediate concern for the physical safety. All right, other physical restraint limitations in timeout. We talked about timeout. A physical restraint must only be used in a situation requiring immediate intervention where reasonable physical force is needed to prevent imminent danger of serious physical harm to the student or others. So what's the difference between immediate concern for the physical safety and imminent danger? Who knows? Imminent danger is in my mind evokes like, if this is happening now, this is immediate. Okay. Immediate concern is like, oh, this could possibly happen. So there is a little bit difference there. This might come up later when we talk about the language to use in the policies. Other important difference in physical restraint now, you used to be able to use emergency interventions to protect property. If a student was, damaging school property, that is no longer the case. All right, we can no longer use physical restraints to prevent damage of property, but there are two exceptions. Again, if there is an imminent danger of serious physical harm to the student or others, and the student has not responded to positive proactive intervention strategies. So we need to be using those de-escalation strategies first, at least according to the guidance. Is that always possible? Maybe not. All right, we understand that there's a certain reality element here. You may not be able, funny enough, looking through that guidance that I discovered last night, it even talks about a scenario in which you're breaking up a fight, and it says, you can use proactive, positive techniques first before you can step in with an intervention. That's not always the case. I've been in those situations. I've broken up fights where I'm like underneath kids, and it's not always possible. So we do have to live in the real world eventually, but let's just be aware that this is what the guidance is saying. All right, so other limitations, there can be no known medical contraindications for a student. You can't physically restrain a student if they have a medical contraindication to it. How do we know? That's, there's a new training requirement. That's one of those things that probably should be addressed in the training. So there's 2 tiers of training, which I don't want to get ahead of myself, but staff who are going to be called upon to implement or possibly implement a physical restraint. Those staff may need to be aware or trained on this, if there are particular students who have a medical contraindication on who can't be restrained. You can't have a student being restrained who has a medical contraindication. Okay, so I'm not going to talk about all these other physical restraint requirements. It cannot be used as a planned intervention. In contrast to timeouts, timeouts can be a planned intervention. Physical restraints cannot be. All right, and something that's not addressed so this is section 19.5. It's not in these regulations, but physical restraint cannot be used on preschool students attending a program licensed by OCFS. So that's under the OCFS regs. They define physical restraint a little bit differently, but it's very clear in the guidance that we're talking about the same thing. Okay. Let's see if there's okay. We've talked about some of these things before, so I'm just gonna roll on. Okay, mechanical restraint. The use of any device or equipment to restrict a student's freedom of movement. Okay. Now the big thing that we've addressed here is this does not include vehicle safety restraints. Okay, so one thing you might think of that comes to mind for me is handcuffs. Okay, and the use of handcuffs by an SRO. So that's a question that's come up. Is that a mechanical restraint? So ordinarily handcuffs, obviously, teachers aren't using handcuffs. Okay, but at least I hope not. And then, but SROs could be, all right? And mechanical and handcuffs would be an aversive intervention that would be prohibited. We'll talk about the difference actually on the next slide. So SROs, how does this apply to SROs? We know the regulations or these new regulations apply to staff and agents of the school. And agents of the school is specifically defined to include school resource officers. So they do apply So ordinarily, in the everyday, day to day, the SROs have to be complying with these regulations. So that's the prohibition on prone restraints, the appropriate use of timeout, physical restraints, and handcuffs. Now, there is a little bit of a distinction drawn once we cross out of the school agent universe and into the law enforcement universe, if we're in, into the criminal world, I guess, so to speak. So under the SED guidance, SROs are authorized to use handcuffs when carrying out an arrest. So if they're effectuating arrest, we're almost out of these regulations. And you can use handcuffs provided that they're in the scope of their law enforcement duties and the use of the handcuffs is necessary for the safety of the student. Now, who's going to be making that determination on the spot? I mean, the SRO, but this is what the guidance tells us. Now, are there going to be situations where handcuffs may be excessive at that, if some student has de-escalated and, we don't need handcuffs to safely walk them out to the police car after being taken out, potentially, we'll just have to address these situations as they arise, but. Okay, policies, procedures. We know that everybody has to have a policy now. It used to be the case where not everybody had to. You only had to have a policy if you were using these types of interventions, but now everybody is required to have a policy. So since these regulations have come out, we know that BOCES has issued sample policies. Those are great. And one of the things that's up to us now, okay, is they leave this section, a couple sections blank for the districts to fill out on their own. So the factors that, and two of the things we have to fill out are the factors that may precipitate the use of timeout or physical restraint and developmentally appropriate time limitations. So we've developed sample language to include and provided that to many of you. But if you're looking for those things, we have some suggested language. So we'll start with physical restraint. So factors which may precipitate the use of physical restraint include, but are not necessarily limited to, that would be important language to include. We can't list every possible scenario. We don't necessarily want to list every possible scenario, but these would be some examples. So as I mentioned, the student is becoming physically aggressive, engaging in elopement behaviors, destroying property in a manner that poses an imminent risk of danger, and the student is engaging behaviors that pose an immediate risk of harm. We talked about the standard would be in an imminent danger to self or others. So, what's the difference between immediate risk of harm and imminent danger? I mean, if we really wanted to get picky, we could probably swap those two terms to track the regulations. But I mean, I think we know what that means. And of course, the use of other less restrictive intervention strategies have been or would be unsuccessful. So that's key to include that. I think just so everybody's aware, to push for those de-escalation techniques first. All right, timeout, very similar language, included, factors include but are not limited to. Again, we see physically aggressive, elopement behaviors, and then time limitations. So this is the suggested language that we've come up with for physical restraint and time limitations. I think the key is, we want to avoid specific time limitations in these policies. You can't, I mean, for the purpose of a policy, I mean, at least we've decided it's not the most prudent course of action to come up with a time limitation for every situation. These are going to be case by case, and addressed on an individualized basis. So, to the extent that we're going to have any, specific time limitations, they should be child specific and indicated in the IEPs or behavioral intervention plans. So this is suggested language. As you can see, it's very general. It doesn't imply a specific timeline. So, if you need to include those in the BIP or the IEP. Okay, documentation. This is everything that's required to be included in the documentation for each incident involving the use of a timeout or physical restraint. If we've developed a form, I think we've provided that to many of you. If you have a form by now, great. If you don't, you can certainly reach out to us for that, but, having a form that addresses all these regulations or all these regulatory requirements is going to be key. We're not going to go through each of these one by one, but we will talk about some in detail. So one of the things that we need to document is parental notification. So we now have a same-day parental notification requirement. The documentation must include, so the documentation that we were discussing, so as you see the last bullet point, the date and method of notification to the parents, guardians, and whether a meeting was held. So one of the things when we notify the parents we have to do is give them an opportunity, ask them if they want the opportunity to meet about this. So we've seen documentation that has a space for, what was said during that meeting, or what was almost like a place for minutes during that meeting. I think that's a good thought, but I think generally that's not a requirement, number one. And, I think we would generally not include something that's not required to be included, especially something like that. I mean, it gives a parent an opportunity to disagree. What do you do at that point if they dispute what was taken down in those minutes? So I would say, I think our recommendation would be to not include that if it's not required. Okay, so, and like I said, so the parents and guardians must be provided with a copy of that documentation. So we have to give that documentation to the parents, so they're going to see what would be included in that. And like I said, we don't need to open up that can of worms. All right, so, all right, one of the things covered in the April update, so we have a same-day notification. So one of the questions that was asked in the April FAQ document was, what if the incident is after school hours? Say you have a dance at the high school and it's 10:30 at night and the kid ends up having to be physically restrained. Well, what they do is say, first of all, they recite the rule and says that the same day notification would apply in that instance. So if it's 10:30 at night, they have to be physically restrained. Technically, you have to give that same day notification. It doesn't mean you have to get in touch with them, but you have to try. So that would be the rule, and you have to document the ways that you tried. Okay, so when do we create a record? For each instance of physical restraint or timeout, and for allegations concerning prohibited intervention types. So allegations of prohibited use of the prone restraint, mechanical restraint, seclusion, aversive interventions, corporal punishment. So that includes substantiated and unsubstantiated allegations. We have to report those instances. All right. There's a question about, what if we have multiple records in one day? When do we need to create more than one document? Well, there's two situations. So a new situation occurs involving the same student after one event is kind of over with, and then we have something new. Okay, they return to their learning environment and they re-escalate again, and they need to be brought back down to the timeout room or something like that. That would be two documentation forms. Or when a new restraint or intervention response type is used during the same event. And the example given in the guidance is this. So during an event, staff person employs a physical restraint on a student, and the situation escalated to the point where a timeout was used. That strikes me as kind of reverse. Usually I think of like a timeout escalating to a physical restraint, but suffice it, it doesn't really matter for the purposes. But we have a physical restraint used, that didn't work, then we're escalating to a timeout. Those would be two separate records, two separate documentations. So I think the key takeaway is we have to be thinking that there are instances where we have to document more than one thing. There could be more than one event that we have to report. All right, let's see if there's anything. Okay, in the April guidance, the question was asked, what about off-school grounds? Like the bus? Yes, okay, that would apply. Or a sporting event or evening event? Yes, okay, those would be reportable instances. Okay, so what about SROs again? So we know that the regulations apply to agents of the school. Okay, so the use of physical restraint by an SRO or other intervention covered under the regs must also be documented and reported. So if an SRO uses a physical restraint, that's also a reportable incident. Now, by contrast, if you call the police and the police respond, okay, those are not agents of the school. Those are acting as law enforcement officers. They have to do what they have to do under their own guidance and protocols. So we're not in that reporting world. Now, you could have a situation where an SRO is acting as an agent of the school and then, assists with law enforcement. We have to address that situation as it arises. There might be specific questions about whether we have to report. Now, let's see, we talked about handcuffs. Like I said, so there seems to be a pretty clear distinction when you are acting as an agent for the school, and when you step out of that, you put on a different hat and you're now a law enforcement officer. So it's possible that you might have to report, one intervention type, and then if you're moving into an arrest phase, you might be out of those regs. But those are good questions to ask as you're going through that. Okay, so annual reporting. So beginning next year, reporting requirements must be submitted to SED. This applies to school districts, charter schools, and BOCES. So we will report this data in the Student Information Repository System, or SIRS, and there's a template online. SED has posted this. Many of you may have already seen this. Just out of curiosity, has anybody seen this? Okay, that is 0 for those of you who are on the webinar. No. Yeah. So this is the link to it right here. So this is the SED has published a guidance memo on how data should be entered. All right, so there's the link for you right there. It'll take you right to that memo. Now, interestingly, let's see. Okay, so there are entities, who might have our students who are not reporting, who do not report to SED through SIRS. Okay, and what's emphasized in the guidance is public schools. We have to have procedures in place. We're responsible for reporting the data for our students who we are the district of residence in many cases. So we have to have procedures in place for collection and reporting incident data for students whom we are the district of residence and whose schools do not directly report to the department via SIRS. Now, you saw that list at the beginning. Most everybody has got to be keeping documentation, but not everybody is reporting it. So the key thing is here, these are the folks who don't necessarily, according to the guidance, who don't report via SIRS. So state-supported schools, in-state and out-of-state private schools approved to provide special education, and approved programs for preschool students with disabilities. So these folks are not necessarily reporting to SIRS. We need to have procedures in place where they're documenting, but we're collecting that documentation so that we can report it. That's our responsibility. Yes.
Non-resident students attending a neighboring district, do we have to report that to their district of residence?
Okay, so say that one more time, please.
On the prior slide, it said district of residence.
Yep.
If we have non-resident students attending the school, do we have to report? Does the district of residence need to report a student attending if they're dual enrolled?
Great question. A non-resident student attending.
We have, not that it happens but a staff members can. So
I got
they're attending the school that way, or we have tuition students in that way. Is it the district of residence?
Well, I mean, the guidance says, whose schools do not report directly to the department via SIRS. So, I mean, arguably, if I would say it can't hurt to collect that data. Certainly, you certainly wouldn't be doing anything wrong. Better safe than sorry. But it says, what the guidance says is schools who do not report directly to the department via SIRS. So if they're attending a school that does report via SIRS, arguably, you may not have to report those students. But the guidance doesn't address that specific question. So I'll be perfectly honest with you. I don't know the answer to that question, but I would say it doesn't hurt. I hear Ann saying yes. So she's way smarter than me, so I'd listen to her. All right. Okay, and the last slide. So this is just a reminder. There's a requirement to review the. Oh, Ann says the district the student attends should be reporting. That's kind of what I was thinking. So if they're attending a school district that reports via SIRS, that would be the reporting entity. So not necessarily us, okay? All right, so a couple last things. We talked about the documentation requirement. That's a requirement that needs to be periodically reviewed by the building administrators. Okay, we need to see who's using these interventions, how frequently, to identify any potential issues, and the training. So interestingly, the regulations say all staff are required to receive annual training. So there's 2 tiers of training. There's what I call the 101 training, and that's under the second bullet point. And that covers you have to be trained on the policies and procedures for the use of timeout and physical restraint, evidence-based positive proactive strategies, crisis intervention, prevention procedures, and de-escalation techniques. So everybody needs to be trained. Everybody needs to get the 101 training. Now, under the April guidance, people are asking the question, well, who's everybody? Does that include the bus mechanic? Does that include, district office staff? And I think rather unhelpfully, the guidance says, and just repeats the rule again, all staff need to be trained. So I think the implication is yes, everybody needs to receive this 101 training, but then there's the 200 level training, which is required for any staff who may be required to implement an emergency, I'm just gonna use the old language, a physical restraint, okay? So not everybody necessarily needs to get that. Okay, maybe one set of training is just on the policies and procedures, and maybe folks who work directly with students get that second level training. Okay, and then the question was, okay, does this apply to SROs again? All right, SROs are my favorite people today. Now, again, it's very clear from the regulations. SROs are considered agents of a school. The requirement under the regulations is all staff must be provided training. Our SROs staff members, I don't know. They're not district employees. Generally, they're in our schools pursuant to some kind of intermunicipal agreement, okay? They're not our employees. But when the question is asked, SED addresses it, it applies, the regulations apply to all staff and agents of the school, and that's what they say. So you can make an argument either way. I would say, if you have SROs and you can get them in the training, probably not a bad idea.
That would be a heck of a voice.
So, in your school, it doesn't seem like you have any students that would ever need restraint. So, do you need to train people just in case? Because that training runs out, they have to recert, blah, blah, blah. Or do you, like, almost in a preventive way? Or, I mean, kids move in and out of districts all the time. I just feel like and it's very hard to get the training. And then it's, 4 days out of the classroom and so on and so forth. I just feel like I don't want to take up a space in that training if I don't have any kids right now that require a restraint. Let Schwartz Central come work for us anytime.
That's a great question. So just to recap, so let's pretend, so maybe we can be more specific. Let's say it's a mainstream school. There's no special classes. There's no 811s. Okay. And there's all the kids with IEPs are mainstream. Okay. And you don't have, and there's a few behavior intervention plans in there, but you don't anticipate any physical restraints, which that probably exists. Sure.
So just,
And then,
so to clarify, the training does not just contemplate physical restraint, the use of timeout as well. So I just want to mention that. Right.
what? I'll just give you my take.
Sure.
I'm curious, Andrew,
Yeah.
is there anything out there on this?
Not that I've seen.
Yeah, 'cause my gut feeling is you'd want one or two people just in case,
Yeah.
like in case of emergency.
Right.
What if somebody comes in midstream? What if somebody moves into your district in January and they're not trained? Do you say, well, do you go home instruction? So, yeah,
I was going to say the same thing. So at, you know, at a minimum, at a bare minimum, we have to do this 101 level training. That's a requirement. All staff has to receive that. And the other point I would make is similarly, you know, along what Jeff said, I mean, a physical restraint, for example, can only be applied by somebody, I mean, strictly speaking, can only be applied by somebody who's been trained. So if you don't have anybody who's received that training, that intervention is technically not available to you. So we don't want to maybe close ourselves off entirely to being able to. So I would say, I would echo what Jeff said, and at minimum, yeah. Yeah. Sure. Sure.
okay.
Okay. All right. Thank you.
All right. Okay. It's a good question. Would you recommend a 100 level training for maybe non-administrators, maybe board members, or just to have knowledge of what the rules are? Yeah. Yeah, it's not required. It's not required, but if someone's looking for information on what's going on the ground floor on the schools, and I mean, knowledge is very for any high administrator or board member, the more knowledge you could have about these rules, the better.
Hey, let me make sure my microphone is working. Good morning, everyone. My name is Candace Gomez. I'm one of the co-chairs of the School Law Practice Group at Bond, Schoeneck King, and I practice in our law firm's downstate offices in Long Island, Westchester, and New York City. I'm thrilled to be joining you here today in Buffalo, and I'm especially thrilled to have this new opportunity to work with a great team of new colleagues, especially Andrew and Jeff and Tracy. We're just very excited to be able to welcome them to the Bond Group, and they have brought such a depth of experience and really great insight into our firm. So we are rocking and rolling and ready to serve you and all of our clients to the best of our ability. So I'm so happy to be here today. I also want to take a moment to acknowledge the extraordinary work that you all do as special educators and administrators. Before we get into talking about manifestation and determinations, I think sometimes it's important for us to look back to see how far we've come, because the area of special education is very new. And I think sometimes people forget about that. According to the US Department of Education, in 1970, US schools educated only 1 in 5 children with disabilities. So most children with disabilities were excluded from the public school setting. And that's only about 50 years ago. After federal laws such as the Individuals with Disabilities Education Act took effect, by the time we got to 2022, more than 66% of students with disabilities were in the general education classrooms for 80% or more of their school day. That's a tremendous leap within a matter of only about 50 years, because first we went from almost entire exclusion of children with a variety of disabilities. Children with something as simple as a hearing impairment were kept out of schools back in those days. And then once they were brought into the schools, we saw certain educators and people who really didn't know how to accommodate those needs, didn't know how to handle them. So they were taking the next best option by saying, okay, if we have to enroll you in the school, that's fine, but I'm going to suspend you for every little thing you do, and we'll just keep you out of the classroom so I don't have to deal with these worries. That's what we were seeing happening, which is why methods such as manifestation determination needed to be implemented so that that could not be used to circumvent the requirement of schools to keep these students with disabilities in the classroom as much as possible. So I bring that out because it is an emerging area of the law. We have colleagues in our 70s who were there right at the beginning of all of this, right at the start of these special education laws. And you've all just done so much to bring us very far in a short space of time. So thank you for that. We're now going to talk about disciplinary changes in placement. So if a student with a disability is about to undergo a disciplinary change in placement, then that student is entitled to various procedural rights. And therefore, it's crucial to accurately determine when a student with a disability is about to undergo a change in placement. So using the term change in placement, and I'm sure many of you have looked at this closely before, but to make sure we're all on the same page and operating from the same set of facts, what are we talking about when we say change in placement? So a disciplinary change in placement is a suspension or removal from the student's current educational placement that is either one, for more than 10 consecutive school days, so we're talking about 10 school days in a row, or on the other hand, for a period of 10 consecutive days or less, when that student is subject to a series of suspensions or removals that constitute a pattern because they accumulate to more than 10 school days in a year. And of course, that student's behavior needs to be substantially similar in order to qualify as a pattern. We'll certainly spend some time talking about what a pattern is, but in instances where we don't have 10 school days in a row, that 10 consecutive school day, that tends to be the easy way to kind of determine when you have to have a manifestation, right? It's very clear to us, student is out for 11 school days, they have a disability, manifestation. The instances that tend to be a little bit more difficult are when, for example, you have a student who is out for 2 days in October for a certain reason, and then they're okay in November, and we have them out for 3 days in December. They come back and then they're out for another 3 days in, let's say, January. That is when things tend to be lost in the tracking process, especially when the incidents don't seem to be related, because administrators, and I understand this is a busy setting and it's fast-paced, they tend to lose track of what happened before. So we really need to make sure that every district has a tracking system so that these mistakes don't occur simply by lack of the left hand not knowing what the right hand is doing, right? If a student is being suspended in different periods of time for different reasons, we always need to have an up-to-date count on where we're at in terms of whether they have crossed that 10-day threshold or not. When we're talking about pattern determinations, what are we looking at? So when there's a pattern of non-consecutive short-term suspensions or removals totaling more than 10 school days, we know that that constitutes a disciplinary change in placement. That means we have to have a manifestation determination review. And again, we need to be able to properly track in order to determine when that manifestation needs to happen. When we're deciding whether or not a manifestation is going to result in what we would call a pattern, we're looking at whether the student's most recent misconduct is substantially similar to his or her behavior in previous suspensions. So one of the most straightforward examples, let's say a student is having a physical altercation with a student in September, and then they have another physical altercation in October. In most cases, we're going to say that it's substantially similar, especially when the circumstances surrounding that physical altercation seem to be pretty much the same. The same could be true if they're being insubordinate with the teacher and, you know, calling out things that are inappropriate of that nature. But that doesn't always present itself to be as obvious as the example that I just mentioned to you. So we're going to talk about some less obvious examples in a moment. But some of the other factors we look at when we're deciding whether or not there is a pattern, we're looking at the proximity of the suspensions to each other. Are we talking about something that happened in September, and then the student is completely fine until June, and then they have something else occur? In that case, we would say there's probably not a close proximity. There's probably just happenstance that it happened within the same year, but not necessarily the proximity that we would use here to establish whether there's a pattern. We're looking at the length of each suspension. So if we have one suspension for something very minor for one school day, And then a few months later, we have something major that happens to require a 10-day school suspension. That also is an indication to us that we're probably dealing with different levels of seriousness, different circumstances that are not going to be necessarily substantially similar. And of course, we're looking at the total amount of time that the student has been removed from school. So let's talk about some of the less obvious examples that I alluded to a moment ago. Context is really important, right? So we can have all the laws and regulations in the world, but if we're not going to put it in a real world context and know how to address it when we have these nuances, then it doesn't help us much. So at first glance, a series of suspensions, they may appear to be unrelated, but as we really look at the factors, they may have more in common than initially meets the eye. So for example, what we see on the slide is we have a suspension, more than one suspension in consecutive months. First, we have one for insubordination, right? Let's say, for example, we've got a high school student in September, they're insubordinate. They tell the French teacher something inappropriate and they're removed from the classroom. Then in October, they're found smoking in the bathroom, early October, late October, now they're cheating on a test. Come around to December, right before a holiday break, they're fighting with the student. Most people would say these are totally different things. Insubordination, smoking, cheating, fighting. One thing doesn't seem to have anything to do with another. No pattern. Let's go home, call it a day. We're all good. But when are the incidents occurring? If they're all occurring during second period math class, for example, then maybe there is a pattern. Maybe this is something that the student is doing to try to avoid being in that particular class because they're struggling with the content material, because they're having some type of interaction with the teacher that is not really serving the class and that student well, and we need to figure out how to better address that situation. So we don't only want to look at what the action is, sometimes we want to look at when the action is occurring, for example, right? We want to look at the specific facts in each circumstance. So that's why sometimes it really is important to have a group, the manifestation determination team, because one brain is not going to be as good as 5 brains, right? Sitting around a table and all of us trading ideas back and forth and trying to determine whether or not there's really something here that we need to look at. Because of course the goal is not just to suspend, but to figure out what is going on with this student and is there a way that we can better meet their needs so that this continued misconduct, misbehavior, and violation of the code of conduct is not going to occur anymore. Do in-school suspensions count? So we receive that question quite often, and in-school suspensions should be considered a suspension for purposes of a pattern determination unless the nature and quality of the educational services provided during the suspension is comparable to what they were receiving before they were suspended. So we see here that there's the matter of Chester County case cited, and in that district, it was determined that if the district is merely providing custodial care during in-school suspension, then it's a significant change in placement. What do we mean by custodial care? That's basically kind of the old school way of you've got an extra classroom, you have some kids who are in school suspension, you plop them all in one classroom and just say, sit here for the day and maybe I'll give you some worksheets once in a while until the bell rings and it's time for you to get home on the bus, right? That's custodial care. There's no attention to that student's particular needs or disabilities. The IEP is not being implemented. There's no special educators working with them. It's literally just a place for them to be until the school day is over, right? That's not going to be sufficient. What you would need in order to say that this in-school suspension was not a change in placement is you would need to show, similar to what was shown in Chester, for example, that the student had the opportunity to work with a qualified special education teacher while they were in ISS, that they were receiving academic coursework and assignments that were in accordance with their IEP while they were in ISS. If you have factors like that, then you'll be able to show that that ISS was not a disciplinary change in placement. Relevant procedures and considerations. So there's no reset following a pattern determination. Every time that the student with a disability is subjected to a short-term suspension, all of the previous suspensions within that school year are going to be considered for a pattern with regard to their most recent conduct. So the reset only starts at the beginning of each new school year. And when we're counting the number of days of a suspension, it's not just a full school day, it's also any part of a day. So I know that there's sometimes confusion about whether or not a student has been suspended for a day. Let's say if the incident occurs after lunchtime and it's 1 o'clock in the afternoon, and for some reason that student needs to go home because school's ending at 3:30 and they just can't be in the building anymore. Many administrators will say, that's not a day, it was only a few hours, it's part of a day. So that would count as a day. And I see a hand over there. Yep, I see Anne with the microphone. Yeah, sure. We're just trying to make sure we get the microphone. Yeah, I think they're trying to capture it for
Gotcha.
people on the webinar to be
Who
able
had
to
that
hear.
great question?
Yeah.
Okay. Here you go.
If a student transfers from one district to another within that same school year, is there a reset then for those days? Because we had that situation and someone, high school principal had asked.
Yeah, I'm not aware of anything in the regulations that would allow for a reset just because the student had transferred. So you would want to look at the disciplinary record for what that student, excuse me, the microphone keeps coming off, what the student had been subjected to prior to coming to you, and add that together with what is happening in your district. Because remember, if the goal is to keep the child in school, then regardless of which school they're being excluded from, it's important to have that manifestation. Right? Okay. We're going to get into some of the other factors when we're talking about determining whether a pattern exists. Of course, schools need to have a process in place to track their students' short-term suspensions. We've mentioned that before. And we know that there are no express requirements for who should perform the pattern determination. But when in doubt, have an MDR. So what do I mean by this? Before we even get to the actual manifestation determination review, unless it's 10 consecutive school days, first you need to figure out, is there even a pattern here that is going to require us to have a manifestation? If it's very clear to you that there is no pattern, then you're not required to have a manifestation determination, even if that student has been out, let's say, for 15 days, non-consecutively, of course, and you find that there's no pattern. If, on the other hand, you're not sure whether or not there's a pattern, it's a gray area, or could be, it could not be, have the manifestation determination review. Always better to be safe than sorry, and to let the team collectively determine whether or not there's a pattern here, and whether or not there's a manifestation of the child's disability resulting in these actions. And a parent may challenge a pattern determination by initiating an impartial due process hearing. So that's another reason for us to make sure that we get it right as much as possible, of course. Okay. When must the MDR take place? Immediately, if possible, but no later than 10 school days after the decision to suspend is made. And the timing of it is also important because, of course, we know we've got super strict timelines when it comes to student suspensions. So a school district has to provide a parent with the CSE meeting notice at least 5 days prior to the meeting in most circumstances. Now, most administrators are going to say, how is that possible? Because if I need to give you 5 school days to tell you I'm having an MDR, but I have to make this suspension hearing happen and carried out within 5 school days, that doesn't really allow for any time to get both things done in the same time period. So there is some flexibility here. The 201, Part 201 regulations direct that written notification must be sent prior to the MDR meeting, but a parent may be provided with notice of an MDR meeting less than 5 days before the meeting if you've got to comply with other applicable timelines, such as the timeline to have a student suspension hearing. One note on the written notification that parents receive, often we get questions about whether it has to be through the mail, which of course can take up to 5 days depending on where you're living. And there is the ability for districts to send emails with this notification if the parent has elected to receive notifications via email, and if the school district has email available as an option. in order to send these notices to the family. What must be in the notice? The written notice to the parent needs to state the purpose of the meeting. Tell the parent what they're coming in for, not just, we're having a meeting. They need to know what the meeting is going to be about, the date, time, and location, of course, the names of individuals that are expected to attend, and that the parent has the right to have the relevant members of the CSC participate at the parent's request. Under the Part 201 regulations, the people who need to attend the MDR meeting are a representative of the school district that is knowledgeable about the student and the interpretation of information about child's behavior, the parent and relevant members of the CSC as determined by the parent in the school district. I'll go back for a moment to talk about that first category, which is a representative of the district that's knowledgeable about the student. Sometimes we know we've got busy schedules and we can't always get the right people in the right place. It's not going to help you, however, if you have an MDR with a bunch of people who've never met the student. They just happen to work in the district and you need to get some people together on short notice for a meeting. You need to have at least one person who's worked with the student, who's familiar with them, and can really intelligently talk about what's happening with the student. So I just want to emphasize that it has to be someone knowledgeable about the student and the interpretation of the information about the child's behavior. And during that meeting, the MDR team should be reviewing all relevant information in the student's file, including the student's IEP, because of course, part of what we're thinking about when we're determining whether there's a manifestation of the student's disability is not only is the plan effective for the student in terms of whether the student is complying with the plan, but is the district also implementing the plan properly, right? So if we have a student with some type of emotional disturbance and their plan says that when they show signs of, not being cooperative, that they're going to be allowed to take a 5-minute break to walk around the classroom. But when they raise their hand to take that 5-minute break, the teacher says, sit down in your seat, we've got a lot of things to do. We're not implementing that plan, right? We're not allowing them to have the accommodations and services that are in that plan. And that could be on us. And that's something that we need to correct if that's the case, if the plan is not working because we're not implementing it properly. And the last slide I'll cover before I turn it over to Jeff is coordination with the superintendent's hearing and MDR meetings. We talked about the fact that these are multi-layered and the timelines may overlap. So Jeff is going to take us into how we handle situations in which we have to coordinate both a student suspension hearing under 3214 of the education law and these manifestation determinations that I've been talking about. Thank you so much.
Thank you. And Candace will be back in a few minutes. We split up the slides here. Just one quick comment on the interesting question about the reset and so on, and that's a bit of a myth that I got this one. Bit of a reset. Another good question is what if you are classified mid-year? Like, let's say you're classified in December and you got suspended September and October. Do those count? And based on the way the regs are written, they do count, but we always get that question. Well, is it fair to count? But it says in the year, and there's no reference in the regs to prior to or before, but there's so many nuances here. So, okay, so Candace just said the regulations give a roadmap for this process. You've done this a million times. You ever wonder why you do things in a certain order? It's because the regs say we should do it in a certain order. And we're not talking about patterns right now. We're talking about long-term suspensions, which is about 90% of the manifestation meetings are going to be offshoots of a superintendent's hearing. And it's actually right in the regs in the Part 201 section, which if you look back, 201.9, if you ever bored and flipping through the regs, it's back there. And I always say this, remember Shakespeare, those really fun plays? Like, Act 1, Act 2. It's, you know, this is it. It's the same thing. So step 1, superintendent's hearing. You do it in this order. This is, you're all in the room with the superintendent or the superintendent's designee, and you have to figure out, is the student guilty or innocent? If the student is innocent, we're done. Go back to class. If your student's guilty, well, we're just warming up. Do you go right into the manifestation meeting after guilty? Technically, you don't. There's another step here. It's called a threshold determination. The hearing officer or the district, either one, it's not clear, is supposed to say, we know he's guilty. Is there a chance the punishment will go beyond 10 days? It's possible the district says, we don't want to go beyond 10. If you do that, then there's no need for manifestation meeting, unless you have a few more, you know, unless you get pattern. But we're just talking about the one-shot deal. So there's an extra step, a threshold determination, which people skip over. Then if you say yes, threshold's met, we're going to go over 10. You stop the superintendent's hearing, and you start the manifestation meeting next door. That's why they're scheduled at the same time. Now, from a practical standpoint, a lot of times you've hired an outside, like a BOCES representative, to be the judge at superintendent's hearing. And sometimes the hearing officer has to go. I can't wait. You're going to go in there. I have somewhere else to go. And that's the real world issue. But if we're going strictly by the rules, we're supposed to stop the hearing after the guilt to innocence phase, after the threshold determination. Then you have your manifestation meeting, and you run in and determine if there's been a nexus. Okay, and we're going to get into specifics about how do you make that decision in a second. But procedurally, if you find there's no nexus, no connection, no nexus, you go back to the superintendent's hearing to continue. Because it's not connected to the student's disability. If there is a connection, you're supposed to go out to the hearing and say, there is a connection. Now that usually will end the hearing process. Don't go to the penalty phase. If, though, what are the exceptions? How do you sort of sidestep a manifestation determination if there is a determination that the suspension involved, the misconduct involved drugs, a weapon, or serious bodily injury? I'm going to talk about that in 1 second. But these are evidentiary decisions that we're going to do in the penalty phase. So if any of these conditions are met, you go back to the superintendent's hearing. I just want to show you this here. So this step, just so we're clear, if you go in and you say there is a nexus, you say, wait a minute, it involved a weapon. Student had a 6-inch knife. You go back in and go, okay, we found a connection, but we want to go for an IAES. What's important is that's an evidentiary decision. The hearing officer has to make a ruling on whether or not it's a weapon, whether or not there's a serious bodily injury, and whether or not there are drugs. And there's a factual threshold for all of those. Sometimes there's a dispute on all those. Is a knife long enough? Is a rock a weapon? Is a scissor a weapon? Is a chair a weapon? Is the injury sustained by the staff member serious enough to meet that threshold? That issue could be litigated and challenged and so on. So a lot of times when you get the questions about, oh, is this, the staff member got a bruise, is that enough? Maybe, maybe not. A concussion, maybe, maybe not. A broken arm, probably. It's a very high threshold. So okay, but again, so this is, we're leaving the manifestation meeting, we're going back to the penalty phase. So again, if there was no nexus found, we're in the clear, and we're going to find, we're going to conduct the penalty phase.
We have a couple of questions.
Okay, cool. Okay. But I just want to say one thing. We're going to conduct the penalty phase of the hearing. But for all you lawyers out there, what do you do in the penalty phase? You talk about all the bad things the student did in the past. Because if it's the first time, the penalty will be small. If the student has a long record, it's going to be a longer suspension. you're not allowed to bring up prior suspensions at the hearing phase. It's prejudicial. The student's saying, I didn't do anything before. I didn't do this. We can't say, well, you did 10 other bad things, so you must be guilty here. That's why it's supposed to be cut off. Question.
So one question is, we know that the manifestation is the second phase of the hearing, and we also know that we're not supposed to suspend a student for longer than 10 days in a row without a manifest.
Yeah.
So what do we do in a situation where a parent asks to adjourn the hearing because maybe they want to get representation or for whatever reason, and the student, we know in general education situations, when a parent asks for a hearing adjournment, the student remains suspended.
Right.
What do we do if it's adjourned longer than 10 days in a row as far as the manifest?
Oh, great question. This happens all the time. We know for certain if in the gen ed setting, if the parent requests an adjournment, the suspension continues. So it's 20 days into day 5, they say, I want a 3-week adjournment. Student stays suspended during that time period. Are we legally required to have the nexus meeting on day 10? There's no definitive answer in the regs, in case law. I always say they're connected. Don't have the nexus meeting until the superintendent's hearing.
Yeah, there's actually
You got a case on that?
random, there's a commissioner's decision that came out recently on this issue. And it's interesting because the commissioner in an appeal doesn't really have jurisdiction over special education issues, but she ruled in that decision that it would be predetermination if we go to manifestation before the guilt portion of the hearing, because we're not supposed to go to manifest unless the student is guilty. So I use that when advocates push to have the manifest out of order, because that decision came out. But I do think that it's still kind of an open question, but I agree that they go together.
And no one's ever challenged it.
Okay.
So, I think it's too big a thing to give up, because parents shouldn't be casually adjourning these proceedings without a consequence.
This is another good question. Okay, you ready?
Yeah.
Okay. If a student is suspended from school for 5 days with a hearing to be scheduled, but the second day of the 5 days exceeds the 10-day limit for a disciplinary change. So basically, while the student is waiting for the hearing, they go beyond 10 days. Is the manifestation held before the hearing, or is the determination of guilt made first?
This is another one of those, there's 2 ways to look at this. You've got that, as Candace mentioned, that 10-day rule saying you have to make the decision have the manifestation meeting within 10 days of the decision. Then you also have, you're not supposed to experience a disciplinary change in placement, which would be going over 10 days without having that meeting. So I think you should have it by the middle of the process, and you run the risk. That's just my take. Like if the superintendent's hearing is going to finish on day 11 of total, I mean, you run the risk of violating the disciplinary change in placement rule by not having the manifestation meeting before. I understand we're getting different. There's different points of view on this. Look, if you're going to be late, hopefully you find no nexus anyway, and everybody's fine, no harm, no foul. But I do think if it could line up in a negative way if you have it earlier. That's just my take. And Ann, what do you think? And Candace, I'm curious your thoughts too on this. Yeah.
Yeah, that's a tough one. I don't have a good answer for that. I think that there's the predetermination issue if you have the manifestation too quickly, but I guess the argument to that would be that the manifest is based on the short-term suspension, not the
Right.
long-term suspension.
See, otherwise these rules are totally useless. If you think about, if we can wait and wait and wait and wait, then they have no teeth. But I know we have a question back there, and then yeah, and then yes, absolutely. And Candace said, yeah, if possible, move up the suspension hearing. Try your best to avoid that situation through anything in your control. Question.
So by that logic, though, if you have it after day 2 of the short-term suspension, right, just by doing that, there really would be no need to come back after the superintendent hearing to do an MDR again, right? So so the worst case scenario is all right, we were gonna find MDR or might find Nexus regardless, either way, we just found it a little sooner. Right?
Yes, right. And so you won't have your day in court to clear yourself of the charges because, yeah, you're right. There's a lot of strange pieces in this process. Maybe I'll have a parent saying, no, I want to have a hearing on that. It's a great point. Okay, so again, penalty phase, but in the simple world where there's no nexus, you go in, you have your penalty phase, you present all the history of the child, you issue your suspension. The last step here is CSE meeting. Okay, so remember we talked about an IAES, so found the nexus, but the hearing officer said you had drugs, weapon, or serious bodily injury, you can place a child in an IAES for up to 45 school days. If you do that, what is the IAES? It's to be determined by the CSE. So you'd actually have to have a CSE meeting a few days later to determine the IAES. Because the superintendent's not going to know where the student should be for those 45 days. That's substantively the decision of the CSE. Lastly, on that note, for the CSE meeting, if there's no nexus and there's a long-term suspension, what's the student's program and services during that long-term suspension? To be determined by the CSE. This step is often overlooked. But if you ever wonder how are we going to service this child during this long-term suspension, CSE should meet. The short-term suspension is an informal process amongst the staff. But if it's a long-term suspension over 10 days, CSE has to convene.
Yeah, for any of you districts that have been cited for disproportionality on these issues, you know that the state is making a really big deal about that CSE process. And they're actually saying that you can't impose the suspension even if no connection is found until you have that CSE meeting first. So a lot of districts are dealing with that by scheduling a CSE meeting automatically to happen after that manifestation determination.
Right.
So that they're back to back.
So this is a very important step in the process. Okay, so let's talk about the manifestation meeting itself. How do we figure out if it's a nexus or not? What are the questions? 3 questions. Was the misconduct, the MDR team is sitting there with the right team. They're asking 3 questions. Was the misconduct caused by the student's disability? Caused by, that's a high standard. Was there a direct and substantial relationship between the misconduct and the disability? Was the student's conduct the direct result of the school district's failure to properly implement the student's IEP? Direct result. 3 questions. 1 yes gets you a manifestation. You don't need all 3. All you need is 1 to get a manifestation. There used to be a 4th question before 2007, which is the IEP appropriate? And if the IEP was not appropriate, it was automatic nexus. Did you believe that? Going away. When some of you were in middle school in this room, I could tell that used to be the rule, but they took that out. So these are the 3 questions. Now, okay, so this caused by, it's very rare. How is a disability going to cause you to do something? Very rare. There might be, like if Tourette's could cause, very unusual for this, and it's even considering this question. We're really talking about direct and substantial. Just also quickly, direct result of the failure to properly implement. This direct result, you got to connect the dots directly. Oh, if you missed a resource room 2 weeks ago and you did something bad, that's not a direct result. If you can connect the dots directly, if you violate a behavior intervention plan, which is an extension of a BIP, not directly led to misconduct, there you go. But it's got to be a direct result. You can't say, oh, he didn't get counseling this week. And well, that could get interesting, and people want, if you want to avoid a suspension, this is the way to go. What's crazy is we've had a lot of hearings lately coming out of this. Andrew and I, we had 2 in the last year, and it's nice to have Ann on the team. It's nice to have a licensed psychologist on the bench helping us formulate these issues. But we're seeing a lot of these, And you've had these claims recently in Rochester, Nexus cases, litigation. And Ken, are you seeing any litigation in Long Island or downstate on Nexus cases? Yep. Yeah, we've had a lot of them and they're expedited, no
They're
extension,
expedited and you can't get an extension.
no
Yeah,
extensions.
it's hard.
So let's get to it. How do we know? This is the toughest question. Is there a direct and substantial relationship? This is tough. This is tough. How do you meet this requirement? There's no general rule to determine if a direct and substantial relationship exists. You have to make a case-by-case decision. So here's what we know. We really have to put on our investigator hats. We know that when they reauthorized the IDA in 2004, sorry, it wasn't 2007, it clarified that, you know, it's something more than an attenuated association. That's one piece. Directed substantial is higher than an attenuated association. So you can't just say, oh, this child has low self-esteem, had to be, that must have led to this conduct. You need something higher than that. So here are some legal principles have emerged here from this. Okay, a couple of things. One, unless there's a clear and direct link, a nexus should not be found. The student's mental state at the time of the misconduct is important. If the student understood that his conduct was illegal, then in most instances, a nexus should be, and illegal is not allowed. Like I'm thinking like I'm a police officer here, like that's illegal, but should be not allowed. And in most instances, a nexus should not be found. There are exceptions. Anne will tell you, like if you have a conduct disorder or something pretty severe, that you knew it was the wrong thing, but you at the time, and it wasn't impulsive, it was planned out, but usually it's not. Impulsive acts are more likely to support a nexus determination, while planned acts generally do not. Again, there's exceptions to these rules. You have to make your own specific decision. These are some general principles. When assessing a student's disability, the MDR team should consider how the student has historically been affected by this disability. This is very important. This is it. This is what we need to know. Conversely, the team should not make decisions based on generalizations about specific groups. So how you have to sit, it's almost like you are rewarding kids for not having a history. This is not a pattern determination at this point, but you have to say, how does this disability affect this student? For instance, some kids with ADHD affects them behaviorally, up and down the IEPs. It's behavior, 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 counseling, a BIP. Another kid with ADHD, it says learning disability, needs extra time on tests, no behavioral issues, never been suspended before. Totally different. Now, if a parent says, oh, Johnny's ADHD must have kicked in, that's why he got in this fight. Like, well, no, that's not how it affects him. Now, that's a great example, and it's not always that clear, but sometimes it is. So for the kid who's never done anything like this before, he might have a tough time getting a nexus. So that's really what it's about. Some case decisions. Again, these cases, it's rare to get these cases. Here's one. You know, again, here's a Pennsylvania decision. We need more than a correlation or an attenuation. They love that word, attenuation. You need direct. You need something direct. In Michigan, an important factor is looking at what was the conduct caused by or substantially related to his or her impulsivity. And when you're acting impulsively, you're not supposed to realize the consequences of your decision. Like, I can't control, I'm in a rage, I can't figure out. But if you're not, if you are able to understand, presumably, you know, maybe you can control your conduct at that point. But it's not as simple as, it's not Law and Order, like you knew it was wrong. It's not as simple as that, but it is relevant. Here's another decision. The student manufactured a bomb. Yes, these kids are smart, you know, you got to give them credit. Engineering major here. But the thing is, he built a bomb over a period of time. You have plenty of time to cool off. Like if you brought a knife into school, that might have been impulsive. And then you left it in your locker and you walked away. You probably said, oh shoot, I left the knife in there. I better get that out of there. Like you don't get credit. The impulsivity at some point has to fade away. Another and here's just a generic statement about the student's actions were disruptive behaviors characteristic of the disability, and students should not be punished. So they're saying, look, this type of disability usually leads to these types of behaviors, and I'm going to find a nexus here. But you really want to look at how have they impacted the student. You should, if it's a surprise that the student did something, it's probably not going to be a nexus. Another one, this was in Indiana, they said that there was no nexus. Again, there was a plan to distribute marijuana, and they understood it was illegal. Andrew and I had a case over the summer, and somebody wrote a hit list. And you could see it was such a long list that it took time. You're not going to, it takes time to, you knew, you put that pen down, you came back to it. And so these are the little things. And, and let me tell you, when a parent hires a lawyer to get the kid out of a 1-year suspension, they will say anything to get them back in school. And this is a great way to get them back. This is much easier to win at this hearing than a superintendent's hearing or a commissioner's appeal. So, again, district failure to implement an IEP, again, going back to that, does not result in a nexus. You need direct result. And again, I mentioned before, the behavior intervention plan is an extension of the IEP. It's tough to get one this way, but it's possible. You'll know it when you see it. You'll know when someone violates it says, don't yell at Johnny in front of his colleagues. He gets upset, in front of bring Johnny over to the corner, say, he shouldn't have done that. Well, the substitute teacher comes in, didn't get the bip, yells at Johnny, something bad happens. Johnny's going to be off the hook unless drugs, weapon, or serious bodily injury. So it's very important, again, make sure your substitute teachers get this stuff. And I think, is it back on to Candace?
We have a question.
Question.
So if a student is found guilty of multiple charges at a superintendent's
Yep.
hearing, should the manifestation team go through each charge individually to see if there's a connection?
Boy, this is, I love/hate these questions. It's possible that there are specific charges. This really gets to the importance of how you draft the charges and what he's found guilty of. So if he's found guilty of some charges and innocent of others, then you're only going to do a nexus meeting on the charges upon which he's been found guilty. So it's possible that you're breaking it down that way. But you really have to start the process early on to make sure that it's specific. And ultimately, you're looking at the misconduct. So if presumably the misconduct is under review, not the charge, hopefully, you should have one charge for each type of misconduct. So if he did two separate actions, led to 2 separate charges. That's why these multiple alternative charges can get things very blurry. But you're focusing on what was the conduct that led to the charge that the student was found guilty of. Is it? Okay.
All right, while they're switching, somebody asked for the citation of the commissioner's appeal that I talked about. So, and that's the one where the commissioner said that holding the manifestation before the guilt finding was predetermination. So that's decision number 18068. And it's appeal of MW and the Board of Education of the Greenport Union Free School District, and it's from January 2022.
Okay, I'm back on here. Thank you. So I am going to finish out the last few slides on manifestations. We've talked about instances in which a manifestation is found, but if the MDR team answers all three questions in the negative, meaning that there's no manifestation, at that point, we know the student may be disciplined in the same manner as a non-disabled student. So basically, at that point, you're treating them the way that you would a gen ed student and imposing discipline in that way. That doesn't completely get you out of the process because you still have to remember to send the parents a copy of the procedural safeguards notice along with the MDR team's decision, even if you've answered in the negative that there is no manifestation. It's pretty straightforward when we know that a student has an IEP or they have a 504 plan that we're going to have to think about manifestations, but there are some instances in which a student does not yet have an IEP or 504 plan, and they may be presumed to have a disability for discipline purposes under specific circumstances. So if the parent has expressed concern in writing to the student's teacher or supervisor or administrative personnel that the student needs special education, that could be a circumstance in which we have to presume that the student may have a disability and have a manifestation. If the parent does not know how to write or that parent has a disability that prevents them from writing, then that concern may be communicated to the school orally. If the parent has requested an evaluation to determine if the student is eligible for classification, that's also another circumstance. We've definitely had situations where a student is in process of being evaluated. We do not yet know if they're going to be classified, but while they're in that process, they would be presumed to have a disability. Or the other circumstances, if a teacher of the student or other school personnel express specific concerns about a pattern of behavior demonstrated by the student directly to the director of special ed or to other supervisor at the school, for example, a building principal. A student presumed to have a disability is entitled to all of the procedural safeguards that a student with a disability would have before we are going to undergo a disciplinary change in placement. There's three exceptions to when a student is presumed to have a disability for discipline purposes. Number one, we're not going to presume that the student has a disability and go through that MDR and disciplinary steps that would happen for a student with a disability if the parent has previously refused to allow the district to evaluate the student for eligibility by the CSE or CPSE, or if they've refused to provide consent to evaluate. So basically, the parent can't use this as both a shield and a sword, right? So either you believe your child has a disability, in which case you're going to consent for the evaluation and the steps that we need to do to address that disability, or you're not and you're refusing, which is your right as a parent, but then you don't also get to ask for the manifestation, right? We want to make sure that if a parent is refusing to provide consent for services, that they have submitted that to us in writing. We've had circumstances where a team will go back and say, well, I know that the parent said no, but did you ask them to put that in writing? That could be an important piece there. And if the CSE or CPSE has previously found that the student was ineligible for classification as a student with a disability, then at that point, we're no longer going to presume that they're a student with a disability. When we're determining if a student is presumed to have a disability, we know that the commissioner's regs authorize 3 individuals to make that determination. We have the superintendent of schools, the building principal, or other school official imposing the suspension or removal. Generally, it is going to be the superintendent or building principal because there are few people who are actually authorized to suspend a student other than those individuals. Section 504 students, we don't want to lose sight of them. We've been talking a lot about the CSE process and IEPs, but of course, the Office of Special Education Programs at the federal level, the United States Department of Ed, they've opined that students classified as disabled under Section 504 have the same or similar protections as students with IEPs, that they cannot be removed from school for more than 10 school days if it's going to be a manifestation of their disability. So under this rationale, school districts are required to follow the MDR process before requiring a 504 student to have a disciplinary change in placement. Many Section 504 students are classified as disabled based exclusively on a physical disability. And there are certain rare cases when a student may engage in misconduct simply based on their physical disability. Jeff kind of took my example earlier, which is when he mentioned the Tourette syndrome, and I'm totally in agreement with him on that. That is a circumstance in which we may see that it's a direct result of their disability. So of course, we know Tourette syndrome, it's a nervous system disorder. It involves repetitive movements and sounds that are unwanted by the person. That could result in a situation where maybe a child is having outbursts in class and the teacher believes that they're being insubordinate. There's nothing the child can do to control that. It's a direct result of their physical disability. That type of situation is rare. What we see more likely are students with intellectual, learning, emotional, or behavioral disabilities in which it may present itself in different ways through their disability, but may not necessarily be the direct result of their physical disability. When it comes to drug and alcohol use, if a student is dependent on alcohol, if they are currently engaging in the use of illegal drugs and they're currently using that, meaning drugs or alcohol, then they are not going to be entitled to a nexus finding if they're disciplined at school for that drug or alcohol use. Okay, so I think that brings us to the end of this section.
And we're going to take a 5-minute break. We have great content coming up. 5-minute break. We're right on schedule, and we'll be out of here at 11:30. But enjoy a few minutes to regroup, and we'll see you in 5 minutes. Thanks. Bye.
Oh, God. I'll do whatever you want to do. I'll do it.
But my slides, they seem step, but it's very shallow.
Okay.
And it's not that good.
I can do it. Hello, everybody. We're back. We have an action-packed second half. And so I know that you're enjoying some socialization, but we do need to get back, please. All right, we're going to get started, guys. Please find your seats. What? It's a drum major. Okay, hi, I'm Ann McGinnis. It's nice to see all of you again. The last time you saw me, I was very pregnant. And my doctor kept saying, you really need to take it easy. And I said, I know, but I need to do these seminars. And so those in the NISBA convention were the last things I did. And when Jeff saw me at the NISBA convention, he immediately said, do you need to sit down? So it was cutting it really close. And the baby came a week later. Everything's great. His name is Joseph. He just turned 6 months old. He's very sweet. So it's nice to be back all together again. So I'm going to talk about classification dilemmas, other health impairment, and emotional disability. This is a real big one. And we're going to highlight some different considerations for all of you to consider on this. So first, generally, for all the 13 classifications, a student is eligible for special education if they have a disability and if because of that disability, they need special education. So you have lots of students who have disabilities, but they don't need special education because of that disability. And if they don't meet classification criteria. And all of the 13 classifications have their own classification criteria written in that we have to reference, but we always have to think about that. Do they need special education because of whatever that definition is within that classification? Something that one of the main things I want you to walk away with today is that formal diagnosis is not needed for a student to be eligible for any of the 13 special education classifications. A lot of people still don't realize this. A lot of school psychologists don't realize this, and sometimes they'll talk about that even at meetings that I'm at, but there is no need for a formal diagnosis. So if a student is classified with OHI, you don't need a formal diagnosis. If a student is classified with ED, you don't need a formal diagnosis. If you think a formal diagnosis would be helpful in that process, there's nothing to stop you from getting a formal diagnosis, from pursuing if there is a formal diagnosis. That's fine if you want to do that as part of the evaluation process, but what you can't do is require the parents to provide you with a diagnosis in order to find that student eligible, because that is not free under free appropriate public education. And that violates our child find obligations that require us to identify all students with qualifying disabilities within our district. So we can't say to parents, but for you providing us with a diagnosis, we can't find your kid eligible. If we think a diagnosis is important, we need to get that either internally through our school psychologists who are able to legally diagnose under the law, but that's a whole different conversation. Or by contracting with some third party, maybe a psychiatrist or a third party to come in as part of our CSE evaluation. Now, if the parents just hand us over a diagnosis on their own, fine. We should consider that. That's part of the information, but we can't require it. Same for Section 504. No need for a formal diagnosis for a student to be eligible for Section 504. The criteria for Section 504 is a physical or mental impairment, not diagnosis, a physical or mental impairment that substantially causes a limit to major life activity. We're going to talk about the emotional disability classification. It used to be emotional disturbance, a real hard thing to tell parents that their child's emotionally disturbed, so I'm glad they changed it. I still think they could do better. I find that a lot of CSEs are reluctant to use this because of the stigma that comes with that ED classification, but I think that we should not be afraid to use ED, because I think that helps combat that stigma of mental health issues, right? But at the same time, the second thing that I want you to walk away with today is classification is not really the hill to die on. And if a student meets criteria for more than one classification, and if a parent maybe is feeling more comfortable with one over the other, fine, that's fine. Because classification doesn't drive services. We're going to talk about that more. Classification just opens the door for that IEP to be developed. So for an ED classification, a student has to have one of these 5 criteria. The first is an inability to learn that cannot be explained by intellectual, sensory, or health factors. So this is a student who's having learning difficulties, but we have to rule out that the reason for that isn't one of these factors. Now, a student could have an intellectual disability or other sensory or health factor and ED. They can have both. But if all of their needs are described by an intellectual, sensory, or health factor, they don't meet criteria for ED. They would meet criteria likely for a different classification, like OHI. And remember, they only need one of these. So number 2, an inability to build or maintain satisfactory interpersonal relationships with peers and teachers. That's self-explanatory. And that could be students who maybe disregard the feelings of others or have social anxiety. They don't know how to make those relationships. Inappropriate types of behavior or feelings under normal circumstances. We see this a lot with difficulties in regulating behavior or emotions. Students may be kind of overreacting to things or having big reactions to things that we wouldn't expect. Number 4, a generally pervasive mood of unhappiness or depression. Again, speaks for itself. Is the student depressed? Is the student unhappy? A tendency to develop physical symptoms or fears associated with personal or school problems. This is like the somatization scale on the BASC. But this could also be a student who's not able to come to school because of school phobia or school refusal, school avoidance, whatever we're calling it. The term, and this comes right from the regs, the term includes schizophrenia. I think it's so odd that that's in there. I started my career as a psychologist working as a therapist in residential, so I saw students with the most significant needs. I've never come across a student with schizophrenia. It's really, really rare for a person under 18 to be diagnosed with schizophrenia, but it's in there. It does not apply to students who are socially maladjusted unless they also have an emotional disability. We have several slides on this. This is confusing. So we're going to break that down. And again, they only need one of those 5 criteria. They have to demonstrate these symptoms or these behaviors over a long period of time. That's not really defined by, it's actually not defined by the regs. What is a long period of time? We know under section 504, anything shorter than 6 months in duration is considered to be temporary. But for IDEA, they don't tell us what a long period of time is, but it should be present for at least several months. So we're not really looking at like an adjustment disorder, which is a temporary need. An adjustment disorder could turn into some other type of diagnosis. We're looking for it happening over a long period of time to a marked degree. So they need to be demonstrating these symptoms to a greater degree than their peers. A great way to figure this out is through standardized assessments. So if we're doing social emotional assessments with a student, if we're seeing that they're really outliers and it's very significant where these feelings and behaviors are coming from for them, that can be an indication that it's to a marked degree. That shouldn't be the only way we do it, but that could be a good indication to figure that out. And then a big one is, does it adversely affect their educational performance? And we really need to look beyond achievement. So something that I see a lot, especially for students with severe anxiety, and especially to get very specific for students with severe anxiety that have school avoidance and they're not coming to school, is the CSE will do an evaluation and say all of their achievement scores are in the average or above range. There's no impact on their educational performance. But the case law is really telling us not coming to school is an impact. If you're not able to come to school, you're having an impact on your educational performance. That likely meets that criteria just for that alone if it's happened over a long period of time. Social maladjustment, it explicitly excludes social maladjustment. We consider this to be kind of like a conduct disorder. Students engaging in criminal rule-breaking behaviors. So again, that is a rule out, but a student can have ED and social maladjustment. And if they have that, they would still meet criteria to be classified. Again, we're going to talk about that more. So social maladjustment is not defined in the regulations. When we look into the research and the literature around that, Stephen Brock is a big expert on social maladjustment. He's published a lot of information on that. They have a bunch of characteristics for what we're looking at to figure out, is this behavior an underlying disability or is it more of a social maladjustment? And it's looking at things like lack of motivation or interest in school, irresponsible behavior, low frustration tolerance, rejection of authority and discipline. For the psychologist in the room, that's a lot like conduct disorder, all of these things. So we're really looking at, is this due to rule-breaking type behavior, criminal type behavior, or is it due to an underlying disability? And also the literature tells us that students with ED are not likely to demonstrate concerns that include significant disruptive behaviors, antisocial behaviors, or socially inappropriate behaviors. I actually disagree with this. I think that we do see lots of kids with ED who have significant disruptive behaviors and socially inappropriate behaviors. I think this is very blurry. But I do think the antisocial behaviors, again, which is like a conduct disorder, rule-breaking behaviors, that is a clear rule out. And a student who is socially maladjusted, again, like I said, could still have an emotional disability, but they could also qualify under other criteria like autism, OHI, if they have other things going on. All right, we're going to talk about some case law. Going quick. Do I sound like an auctioneer with how fast I'm going? I want to make sure we get through this. Okay, so case law. So I want to start out with a lot of these cases involve tuition reimbursement cases. And in a tuition reimbursement case, what that means is a parent disagrees with whatever the district is offering for their child, and they place their student in a private school, and they initiate due process for the district to fund that private school placement. And these in due process land are the heavy hitters, because these private placements can be very expensive. We're seeing hearings $250,000 a year for tuition for some of these private placements. Residentials are included in this umbrella that I'm talking about, and we don't get any state aid for that because they're not SCD approved typically. And if there's litigation, if it's through a due process hearing, we don't get state aid for that. So this is a big deal for districts. And in order for a parent to be able to prevail and be entitled to tuition reimbursement, they have to win on three things. Number one, the district can't prove that it offered the student a free, appropriate public education. So the district can't prove that the IEP that we offered provided a FAPE to the student. Number two, the parents have to prove that their private placement is appropriate. That's usually pretty easy to prove. And then number three, the equities. The parents have to prove that they participated in the CSE process and they were fair in that process. Also really easy to prove. So the FAPE issue is the biggest one. That's what we want to win on because it's hard to win on those other two issues. And for these cases that we're talking about, for the most part, the districts didn't classify the students and the parents unilaterally placed. So the district had to win on proving that the student didn't need to be classified. That's because there was no IEP to defend. That's really hard to do, almost impossible if you haven't done an evaluation and gone through the CSE process. So when in doubt, even if you think that the student doesn't meet criteria, if you're seeing some of these behaviors brewing, if you know the parents are exploring private placements, refer them to CSE, do the evaluation. Even if you find them ineligible, you've placed the district in a much stronger position to defend. So in this first case, which was a tuition reimbursement case, the student was in a private school, general ed school. He was expelled. He had criminal charges against him for property destruction. The parents enrolled him in the public school for a very short period of time. In 10th grade, for the first time, he demonstrated some emotional symptoms. The parent placed him in a private school. They wanted tuition reimbursement. The district never classified the student, and the parents said he should have been classified with ED. And what they found was that the depressive episode was minor and it wasn't over a long period of time. And the behaviors like the drug and alcohol abuse, truancy, defiance, refusing to participate in school, that was all due to social maladjustment. And there was no indication that there was any other underlying disability. Everything could be described, could be attributed to the emotional maladjustment. And so the student was not eligible for an ED classification according to the court, and the parents did not prevail on the tuition reimbursement case. Now, if he was eligible, it would have been very hard for the district to win because there was no IEP. So they only would have been able to win by either proving that the private placement wasn't appropriate or that the parents were not cooperative. For this next case, another unilateral placement, where the parents placed the student in a private school. The student had a history of academic problems, behavioral problems, legal problems, but her achievement test showed that she was making academic progress. She was diagnosed with PTSD, depression, and ODD. She had difficulty attending school. She was on homebound instruction. And the court said that she was ineligible for classification because everything was attributed to the social maladjustment. Similar for this next one on this slide, the court held that the frequent truancy and work refusal Oh, the court held that she could qualify for an ED classification because she met the criteria, but frequent truancy and work refusal was due to the ED, and she also displayed a general pervasive mood of unhappiness or depression. And the holding on this, a quote from the court, the major depression, not just her misconduct and manipulation, were underlying her difficulties at school. So the court said, yeah, there is some social maladjustment there, but there's also an underlying disability as well. And this next one, a student with bipolar disorder, she had multiple discipline referrals due to aggression and insubordination, was eligible for classification due to an inability to build or maintain satisfactory interpersonal relationships. The student was in 9th grade, and since 5th grade had numerous suspensions for threats against students and teachers, many suicidal comments for a number of years, performed poorly on tests, and the court found that the student met criteria for ED and also OHI due to an ADHD diagnosis. And then this next one on here, this Williamsville local one, these are all public decisions. The SRO found that the student could qualify for ED classification, even though the student was socially maladjusted, because the student was eligible for services due to school refusal, work avoidance, poor academic performance, which indicated an inability to learn and an inability to develop positive relationships. So they really get very specific. And when we go to these hearings, hopefully we have our evaluation, hopefully, but the parents are also going to have their evaluators who come in and give some, what they're going to call expert testimony on these issues. All right, we're going to pivot to OHI. A lot of students who qualify for ED could also probably qualify for OHI. It's possible. OHI is kind of a catch-all. It's a weird definition: limited strength, vitality, or alertness, including a heightened alertness to environmental stimuli that results in limited alertness with respect to the educational environment. And it's due to chronic or acute health problems, and there's a list of those within the regs, but that's not an exhaustive list. So asthma, ADHD, diabetes, epilepsy, a heart condition, hemophilia, et cetera. And it has to adversely affect a child's educational performance. So again, we need those two prongs in order to get there. So how do we know if a student who comes to us with some kind of health condition, if that adversely impacts their educational performance? Oh, before I get into that, let's talk about other health considerations. So, like I said, that list that I read is not exhaustive. It could be other things. The limitation does not need to be the result of a physical health problem, and it could include mental health needs. This comes right from the Federal Education Department. In 1993, the Federal Education Department opined that a student with ADHD could be eligible for classification if the condition limits the child's alertness to the educational environment in a way that adversely affects educational performance. So a student being inattentive or impulsive in a way that doesn't allow them to attend to school could be enough for the OHI classification. There's been a lot of talk about, should we have a separate ADHD classification? And the Department of Education has consistently said no, that falls under OHI. And don't forget, even if this student doesn't have an impact on educational performance, if they have a health condition, they might require Section 504 accommodations if it substantially impairs a major life activity. So ultimately, the CSE has to determine whether the student's health condition is adversely affected. Adversely means there has to be some kind of significant impact at school. Affected means there has to be a link between the disability and that impact at school. It has to be current. So a lot of times parents will bring up, well, this could be a problem and I want this in place to prevent that from happening. I understand that sentiment, but that's not what special education is about. It's about what the current need is, not what we're projecting to happen in the future. It's also not about past needs. So maybe a student needed that support in the past, but if they no longer need it, even if they still have that disability, they wouldn't be eligible for classification. Ultimately, the CSE should make these decisions for both ED and OHI if there's that adverse impact. And if we're saying before we do the evaluation or the referral, you know, there really isn't going to be an adverse impact here, we're making a CSE decision outside of the CSE process. If there's any question, if there could be, we should do the evaluation and let the CSE decide if there's an adverse impact. Otherwise, it would be predetermination. This is an SRO decision from 2011 where a student had ADHD and anxiety. It seems to be the combination we see so much for so many students. And the SRO found that the first prong of the OHI classification was met because the student had those diagnoses. Again, diagnoses not required, but they are part of the consideration if the student has them. But the SRO also found that it didn't adversely affect the educational performance and the district had lots of data to help back this up. So they had referred the student and they did an evaluation and all the evaluation scores were at least in the average range. The student's report card grades were also in the average range. The student didn't show any signs of anxiety during a classroom observation. The student progressed socially and didn't have any social needs. There was no increased anxiety or work avoidance when academic pressures increased. So the student psychiatrist testified that that would happen, but the district had evidence that that did not happen. The student was able to learn strategies to cope with anxiety when provided with explicit instruction in the general education setting. And there was no adverse social emotional functioning because she was friendly, respectful, compliant, and had a good sense of humor. And so for all of those reasons, the SRO said that the student did not meet classification criteria for OHI and did not, by reason thereof, need special education and related services. This next one was a student with diabetes, celiac disease, and hypothyroidism. The parents unilaterally placed this student and then initiated due process for tuition reimbursement and said that the student should have had an OHI classification. The SRO disagreed and said there were some relative weaknesses in reading and recalling information, but that didn't arise to the level of needing classification or having an adverse educational impact because overall the student's performance was satisfactory. There was also no evidence that the student experienced problems concentrating or limited alertness. The conditions were well controlled. She made good progress in the general education setting. She had average academic performance, maintained attention, followed directions, and organized her school materials, and functioned on grade level without the need for special education. So I said this at the beginning, but I'm going to say it again. The days of just looking at achievement when we're looking at the adverse educational performance are over. Those days are over. So we really have to, it's still important. It's still an important part, but we need to look much more than that. We need to look at whatever the student's presenting needs are. If we know they have anxiety or if they have symptoms consistent with anxiety, if they don't have a diagnosis, for example, what is that anxiety causing in school? And we can only figure that out through an evaluation, through a CSE or a 504 evaluation. And we should look beyond just their cognitive ability and their achievement. We should look into rating scales and clinical interviews and classroom observation and consultation with their teachers to figure out how they're presenting in school, what type of support they need to make that determination if there's some kind of adverse educational impact. And then that should be brought back to the CSE to make that decision. And there's some case law on this. You can see these decisions are a little bit more recent because, again, the landscape is changing on this. So in this first case, the Southern District of New York found that CSEs have to take a broader approach and consider other academic considerations beyond grades, such as attendance, homework, and organization. Attendance is a really big one. If you have a student who is struggling with attendance, we should think about, could there be a disability-related reason for that? And if there could be, then we should refer to CSE. Other considerations beyond grades include feedback from teachers and standardized test scores, and this other decision from the Southern District. The Office of Special Education Programs with the Department of Education found that students with high cognition and ADHD could still have OHI to address a lack of organizational skills, homework completion, and classroom behavior. Again, these are things that we can get out of rating scales. So we can give a brief maybe if a student has ADHD or symptoms consistent with ADHD. Sometimes school psychologists will say, why would I give a brief? They're already diagnosed with that. Well, the brief will help us figure out what these symptoms are looking like in school and how those compare with a norm sample of gen ed peers, right, of typical peers. So it can help us figure out if there is a need above and beyond general education. All right, and the final slide. Classification does not drive services. A CSE, again, we don't rely on the disability category to determine the student's needs. And I find that CSEs get hung up on this a lot, and for good reason sometimes. We feel like we should find the best one that describes them. And I guess in a perfect world, we should. But it really, it isn't, again, the hill to die on, because it just opens the door for an IEP. And when you're developing that IEP, it's their needs that drive what programs and services and goals they have on there. It's not their classification. And so you can have a student with a learning disability classification who also meets criteria for maybe another classification, and that's okay as long as they actually meet learning disability, right? But the IEP has to describe what their needs are. That's why at manifestation, we can't just look at classification and say, well, they have a learning disability, there's no way there could be a connection, because the IEP might have a lot in there about social, emotional, and behavioral needs. So again, don't sweat the classification too much. The only exception is autism, by the way. The autism classification does have some of its own requirements. Like, for example, if a student is classified with autism, they have to have parent counseling and training on their IEP, and some other things as well. But other than that, the doors are open. You can, any classification can be whatever's on the IEP, as long as they meet the criteria, the classification doesn't matter. Any questions, comments, reactions? We have a question. We're coming.
Just a quick clarification. Did you say a student who's classified autism has to have parent counseling and training on their IEP?
Yes.
Has to.
Has to, yes. There is a provision of like in part 200. I can't remember the citation. It's towards the end of 200 that is just on students with autism. So yeah, I recommend, a lot of people don't know about that, probably because it's so far down right in there, but yes. And there's other circumstances where students have to have that on their IEP as well.
Is that parent counseling?
Yes.
Yeah, yeah. The others is, it's a 611, an
Right.
811, or a 1213.
Right.
They're supposed to get parent counseling also.
And call it parent counseling and training. I see a lot of times CSEs will call it something else, but we should really call it what it's supposed to be called.
So that is a practice that we do already in our district. However, I'm at the high school level. I have parents that are now saying they no longer feel that it's necessary. They don't want it. I am putting it and memorializing it up in the IEP meeting notes so that we can reflect back that it was offered, but they've denied the services as they feel it's no longer necessary. Is that appropriate?
I would still put it on the IEP and just memorialize in the PWN that the parents don't want it. That's what I would do. Just because there are some cases out there where if parents change their mind and say, you know what, that should have been on there, they've ruled, the CSE, the district members are the experts. You need to make sure that IEP is appropriate even if the parents don't want it. So they've essentially ruled that parents declining a service is not a valid defense if the student actually needs it. There's no requirement for how much parent counseling or training you put on the IEP. That's for CSE to decide. Thank you.
All right, thank you, Ann. So bonus time before I get two quick bonuses. The myth buster. So we spoke over the past year about the FAPE goes to age 22, right? Now in New York, based on a Second Circuit decision, child's entitled to a FAPE until they turn 22 or before, if they get a Regents or local diploma. And it was a federal court decision that led to all this. And SED issued a guidance document saying that this is what it is, FAPE until your 22nd birthday. And you have discretion to go from your 22nd birthday to the end of June. That's discretionary, it's not required, but the requirement is up to the 22nd birthday. Last month, a trial court judge in New York State, somewhere upstate, said, I disagree with that. Interesting. So it got people saying, hey, is this off? Is this still the rule? That decision's being appealed. So SED wrote a memo and said, the rule is status quo is the rule. So It's still 22nd birthday FAPE. And you can make predictions on whether or not the Court of Appeals will overturn that. I don't think they're going to. But if anyone says right now that is a FAPE 22 still the rule, yes. Second bonus, there's this talk of new 504 regs. New 504 regs are going to change the world. 504 regs, 504 regs. There are some 504 regs that are coming out. They're not Department of Education 504 regs. They're Department of Health and Human Services 504 regs. There will be some impact to schools and it'll come out over time, but this isn't some earth-shattering development where 504, as you know, it is changing. And I don't know why it's being publicized as this, but it's not Department of Education. So just kind of wanted to get that out there. Okay, let's get to the real stuff. Parental consent. So the slides that we have here are really good because I made them. No, but keep these slides because a lot of this stuff is issue spotting. You're not going to remember all this stuff. And when I came up I've never done a program like this. So to put it all in one shot. So keep these slides and we're going to see what I'm talking about. So we all know you need consent. Consent is a big deal. You need consent for services and evaluations, but there's a lot of specifics here. So we know if it's an initial CSE evaluation, we need parental consent. Now, whoever's the parent has to sign the consent. Sometimes there's a designee. Sometimes there's a court order on who has decision-making, but we need consent from a parent or a guardian. And we know that if you give initial consent to a CSE evaluation, you have 60 calendar days to finish the evaluation, and you have 60 school days to get the CSE to meet. So, number one, does the 60-day timeline to finish the evaluation apply if the parents refuse to produce the student? We know that it doesn't apply. So if the parent signs consent, but doesn't give Johnny for the test, 60, you have more time. But that only extends the evaluation timeline. It doesn't extend the timeline for the CSE to convene. CSE has to still convene within 60 school days. So you might be sitting at this meeting with nothing. It'll be easy meeting, say you're not eligible. But there's rule number one, you have a little extra time if they consent to an evaluation but don't produce Johnny right away. Now, if again, I mentioned before, we must get parental consent. We can't evaluate without parental consent. So step one, it's consent to evaluate. What if we think Johnny needs an evaluation? So we send a referral and a consent, we send a consent form for Johnny to sign. What if mom or dad refuse to sign the evaluation form? What do? We have two options. Option one is to say, well, we're done. And we offered, and we're okay. We're actually off the hook, FAPE-wise, if we offer an evaluation, parents don't sign. The other option, if Johnny's mom doesn't sign consent, is we can initiate an impartial hearing to override the parent's refusal to evaluate. Now, this never happens. Why? Because you need a board authorization. You have to go to your board and authorize initiation of a claim. But and then you have to appoint a hearing officer and convince the hearing officer that you have the right to evaluate Johnny. Now, let's say you win at this hearing. I never in all my career have gotten to this point. But even if you win at the hearing, how do you get Johnny physically to be evaluated is another issue for another day. But again, if the parent doesn't consent to an initial evaluation, you could initiate a hearing to override the consent. It's not mandatory. You could also have an evaluation, a conference to try to get the parent to convince, to withdraw the blah, blah, blah. So reevaluation, we all know that once you're in the pipeline, you have an IEP, we have to reevaluate every 3 years. We know this, and we need consent to reevaluate. But there's a strange rule for consent for reevaluation. There are circumstances where you can go forward with a reeval without parental consent. That's if the parent fails to respond. How bizarre. So if you say it's time for a reeval, please sign this. Now, if the parent says no, then you gotta think about, like, initiating overriding. But if they don't respond at all, you could somehow do this. People are uncomfortable with this. So practical tips, you need to show, you can't just send one consent and say, you didn't respond, we're good to go. You need multiple attempts. I would send multiple consent forms. Please sign, maybe a call. Why aren't you signing this? Blah, blah, blah. But have a record. And although permissible, you don't have to evaluate under these circumstances. You can, but you don't have to. Some people are uncomfortable. Now, what I suggest, if you're going to go this route, if they totally don't respond at all, I think you should still notify them that you're going to do this. That might prompt a response. Say, just want to let you know, you don't have to do it this way, but some people are more comfortable doing it this way. And some evaluators are not comfortable doing this. So, which is probably why they won't do them in most cases. This is pretty unusual, but you do not need parental consent under certain circumstances. Crazy. Here's a special rule. How about this? This is fun for your parties. If you have a child with an IESP, because they're in a non-pub or they're homeschooled, you cannot override their refusal to consent. They're immune from this rule. It's weird, but it's in there. So you can't override those kids. Okay, let's say you provide consent for an evaluation. Parent signs consent. You're ready to get started. We're ready, coming next week to your school to evaluate. Can the parent change their mind? Can they revoke consent for an evaluation? There's nothing in the regs that contemplates this. Bizarre. You can do it for services, which we'll talk about in a few minutes. There's nothing in the regs that says, change my mind. So what do you do? It's not really clear what you're supposed to do in this situation. It's if they can change their mind after they make a referral, but before they consent. But it's not clear what you do in this situation. And anyone that says you can do it, they're probably right. They can't. I mean, what are we going to, like, we're not going to tackle the kid and do it against him. So what do you do procedurally? Years ago, like, there was a system that you record data in statewide that matches up to a federal system, and there was nothing, we didn't know what to do. So what do? I mean, would you just consider this a withdrawn referral? I mean, no one's going to close your school down if you do that. But you have two logical options. You could say, I'm going to treat this as a withdrawal of the referral, or you go forward with the CSE meeting and you don't classify. But this is a strange, bizarre hole in the law. And again, no big deal, because you're not going to classify anyway without any data. But I just wanted to point out, this is right there. So two options: treat it as a withdrawal, which is probably the best way, or have the meeting and say, we got a referral, you didn't consent to anything. Oh no, you didn't produce your child for the evaluation, remember? And then say you're not eligible. Very strange. There's no, what if the parent withdraws consent after the evaluation? I don't like this eval. I'm taking back my consent. Do we have to ignore it? The answer is no. There's no law on this either. But in criminal law, they call this the fruit of the poisonous tree. Like if somebody, let's say that admit to something and you didn't read them the Miranda rights, you could say, well, I'm not going to consider that. Can we use that logic here? There's nothing that says that. So I think you have to consider that evaluation, even if the parent says, I changed my mind. Now, I listen closely to what the parent is saying. Why is the parent upset? Why is the parent objecting? But if you have an evaluation and it's legitimate, there's no obligation to ever ignore it or just disregard it. So, but I just wanted to point that out. You can get all these weird scenarios. Consent for services is easier. Now, remember we talked about consent for for evaluation. You also need consent to implement an IEP. So do we need parental consent for that? Yes, you must get parental consent before you start implementing. So without parental consent, you can't provide special ed, and you're also off the hook. You can't be you won't be found to have violated any FAPE obligations. So if you develop an IEP after an evaluation and the parents refuse to provide consent, we're off the hook. We can't be found out of compliance with anything. Parental consent for the evaluation is not construed as parental consent for services. They're different. And in contrast to a refusal to provide consent to evaluate, the district cannot override a refusal to consent to services. So it's almost like, well, if the parent didn't consent to an evaluation, you know they're not going to consent to the IEP, so why bother initiating a hearing? This is some of the logic that you get here. But you cannot override this under any circumstances. If a parent, we can't be fined to have violated child fine. Now, could you go to CPS and say, hey, look what they did? Maybe if it's a severely disabled student and they're not consenting to an IEP, you might have a case there. Where is the line drawn between it's a mild disability versus a severe disability? What's a CPS violation? Nobody knows, but that's our only possible option. Revoking consent for services. So let's say you do consent to the IEP, and in the future, can you change your mind and say, I'm done, I'm revoking this? And the answer is yes, you can revoke consent for services. You may not be able to revoke consent for an evaluation, but you can revoke consent for services. This was not always the case. For the people who are relatively new to the profession, you might not have known that. But this was pretty mind-blowing when this first came out. But you can revoke, parent can revoke consent for special ed services. Now, if a parent revokes consent, it has to be in writing. And once it's in writing, we have to stop. Nothing we can do about it. We must stop the IEP implementation. We cannot override the parent's refusal. And we're not going to be considered to be in violation of child find or a FAPE. We're not required to have a CSE meeting to memorialize this. So we're done. Now, this is not a declassification. So we're clear. We shouldn't refer to this as a declassification. This is a revocation of a consent for services. Very important. Before stopping the services, parent writes a letter saying, stop implementing the IEP, I revoke consent. We have to send them a prior written notice letter setting forth the consequences, saying, okay, we got your revocation of consent, so we'll give you 3 days to change your mind, and if you don't change your mind, we're stopping everything. And you should list in writing the consequences. You won't, and there's a lot of good letters on Frontline, but please don't skip this step. If you skip this step, we could have problems down the road. We have to tell the parents they're not getting an IEP anymore. And you could specialize, you could specify and personalize this letter. For instance, if it's an athlete and we think the student is going to fail because they're not going to have an IEP, we could say, FYI, we have a no pass, no play rule. So if you fail, you're not going to make the team. Or if you have a disciplinary history, you're going to say, you're not going to get nexus rights anymore. So they're not considered suspected of a disability. They're totally off the hook. So you have to put that in writing. And then they're not, no more protections for discipline. If they're re-referred back to the CSE, we start from scratch. So if they withdraw consent and they refer back to the CSE, you have 60 days to evaluate. You have 60 school days. Now you have discretion to say, we just tested you 6 months ago. I'm not going to do the whole eval. You have that discretion if you want to, but you don't have to. And also, sometimes kids get suspended after the parents revoke consent, and then they refer. If they refer while you're suspended, it has to be expedited. So they would get 15, you'd have to evaluate within 15 school days and 5 more school days to have the CSE meeting. So they'll be suspended for at least 20 more days. And unfortunately, this is the circumstances that we see. So we just went through a lot of options, got to pay attention to what's going on. Parental consent for 504. Section 504 does not expressly require consents for evaluations or services, but OCR is determined, yes, you do. So presumably the same rules apply for 504. I would follow the same. So if you consent to a 504 plan, parent could withdraw the 504 plan at any time. So keep that in mind. Now, partial consent. Now, the devil is in the details here. What are we talking about? Partial consent for an evaluation or partial consent for services? Really got to pay attention, different circumstances. Is partial consent for an evaluation allowed? Okay, we refer a child and we wanted, here's our evaluation. We want to going to do a psych, a speech, we're going to do some of this, some of that, throw in the kitchen sink, sign it. Parent says, crossing this out, crossing that out, add this, sign this. Partial consent, right? That's not consent. There is no partial consent for an evaluation. Parent can't pick and choose. If you don't consent to everything, it's not consent. And if you don't do that, remember, if it's an initial, we're off the hook. So there's a lot at play right away here. So again, they cannot pick and choose. And there's certain, they could say, I don't like the evaluator, I don't like the timeline, I don't like this. They're not allowed to do that. Remember, they have a right to an IEE if they disagree. Now, what about partial consent for services? This is different. Got an IEP. I got to list all these great services. Can the parents say, I'm going to consent, but only to some of this? The answer is no. They really shouldn't be able to do that. Now, there's the guidance says, well, if the parent is objecting to something in the IEP that's not needed for a FAPE, it's okay for the school district to take that out. My thought is, why would it be in there if it's not needed for a FAPE? So going back to the parent consent one, could you take that out saying it's not needed for a FAPE? I don't know. I mean, it says they're entitled to it. So this is where we get into problems. But some schools will say, I don't need the headache, or they'll say, I want to do what's right for Johnny. I know they got parents who are difficult. I'd rather him getting some services than none. And that's the logic that they use, but that could have weird outcomes. And if you want to, sometimes you play hardball and you say, you don't like some, you get none, and then maybe they'll come back later and change their mind. Sometimes schools that are heavy-handed, I don't know if that's the right way, but not as flexible, get the better outcomes. So again, strange rule on that. So Does New York have a rule to the contrary, though? If you look in the regs, look at it. It said, but they'll say, Jeff, you can have partial consent for services. Because look what it says. It says a school district may not use a parent's refusal to consent to one service or activity under paragraph 1 to deny the parent or child any other services, benefit, or activity, blah, blah. Wait a minute, Jeff, what are you talking about? It says it right there. This doesn't mean what you think it means. They're not talking about special ed services here. So what they're saying here is, yeah, you can't deny, if someone denies consent for an evaluation, sorry, for a special ed, someone denies consent for an IEP or refuses, you can't say, can't go on the trip. You can't drive for the team. You can't come to school. But what it does mean is you can't get some special ed services and not all. So it doesn't mean what we think it means. Now, could the consequence be you get suspended and you can't go on the trip? Sure, but you have to pull the dots out even more. So trust me when I tell you, there's no partial consent for services in IEPs. Now, wait a minute. What about non-compulsory? So you got these strange little side issues. What about kids in a non-pub? They're not in school. They're saying, school district, I don't want anything to do with you. I'm going to a parochial school. I know your IESP says I should get speech, OT, and resource room, but I only want speech. Do they have the right to consent to partial? It's interesting, right? Well, does this open the door? It's a good question. From a practical standpoint, like they're leaving. So you could make the argument they could pick and choose. Nobody knows for certain what to do. And I know that you could take the position that it's all or nothing. But something to keep in mind is these students, unlike kids with IEPs, they're requesting services by June 1st of the previous. Does their obligation to request services change anything? I don't know. But that's a distinction. And I do see schools, they're more flexible with these situations. They'll give you some if you only want some. But they have to request services. That's not a requirement for IEP students. What about non-compulsory students eligible to attend kindergarten? This is a very unique group of kids. The kids whose parents keep them out of kindergarten, but they're eligible to attend. And they get an IEP from their home district. You may never have heard of this rule, but this rule exists. And they kind of get CPSE treatment, but it's not really. So these kids, again, they're not compulsory. Can these parents say, I know you'll give me X, Y, and Z, but I only want 1 or 2? Do they have the right to pick and choose? Again, similar, they have to request these services too. Are they any different? Nobody knows for sure, but I do see, now I got one more for you. Extended school year services. Are these mandatory? If a kid has ESY services and doesn't attend, can we call CPS and say they should have went? I mean, it's not really clear, but I think it's viewed as it's not mandatory. You're not, it's not CPS. Can a parent refuse ESY and not get in trouble? I think the answer is yes. No one calls CPS on these students. Do they have right to ask for some and not all? I'll tell you what's interesting. You can make the argument that they're different. I'll tell you why. Years ago, you used to, let's see if anyone remembers this, kids who used to be 10-month IEP students, and they initially went to 12 months, those kids needed special consent for those 2 months. Do you remember that? And they got rid of that rule. That rule's gone. So once you're in for initial IEP, you don't need a second one. So arguably, that gives you less flexibility and less power as parents. So it's weird. I brought these up because they're strange. It's not on, if some schools are more flexible with these. I'm not saying you're right. I'm not saying you're wrong. But if they're not compulsory, they're not mandatory, maybe they're less of, maybe FAPE doesn't apply here, who knows? But I just wanted to point out, it's not as clear cut for those situations. If you want to take the position, it's all or nothing, you can certainly do that. There's no case law on here, but I wanted to bring that up. Okay, one more, the old trickaroo. Can a parent with an IEP revoke consent for an IEP and say, I want a 504 plan? Are they entitled to that? And there's case law. Well, in 1996, OCR said no. How about that? They said, since an IEP is higher than a 504 plan, district has fulfilled its obligations under 504 by offering an IEP, parent can't take both. Now, some districts, so that, I don't know if you knew that, but we could take that position. There are some court decisions on this. Not all of the court decisions follow OCR. There are some court decisions that say, not so fast, give them a 504 plan. There are some decisions that say, nope, you don't get a 504 plan. We're seeing a bit of an emerging rule with, if you have two disabilities, one's medical, one's educational, everybody agrees you should give a 504 plan for the medical. For instance, you have autism and a seizure disorder, and they revoke consent for an IEP, probably a good idea to have a 504 plan just for the seizure disorder. Do you have to do that? Maybe not, but I'm seeing them do that. But from now again, going back to the staff saying, do what's best for Johnny, you might have a kid who has behavioral issues, should be in an 811, and revoke consent, and they're sitting in a mainstream class and they want a 504 plan for behavioral accommodations. The principal will say, we got to help Johnny. We got to help Johnny. He needs his 504 plan. It's better than nothing. Sounds great, right? Then Johnny gets suspended and he goes, hey, I got nexus rights here. And so you're in this untenable position. So be careful what you give here, because there are protections with 504. Does the hard line work in that situation? It might. To say you're not getting nexus rights. You used to have an IEP, no 504 plan. Then suddenly the student gets suspended for a month or two. Parent might say, oh, I made a bad decision. I'm going to re-refer. And then you get them back with an IEP. So something to keep in mind. Sometimes doing the right thing with this doesn't always make sense. And one more even. I got a crazy one. What about, I didn't even mention it here, but you could have a situation where, what if you have a 504 plan? This is the worst situation. What if you have a 504 plan and it gets so bad, you refer the student, let's say it's a behavior situation, 504 plan, behavior accommodations, BIP, gets worse. Say, geez, this kid might need an 811. And you give them an IEP or CSE referral, and they refuse to sign it. Can you take away the 504 plan? We've done it. We've threatened it. But again, why would that situation be any different than the student coming up the ranks with nothing? But I get it. And so there's a lot going on here. So my tip for this is keep the slides handy. And when these issues arise, really ask exactly, are we talking about services, evaluations, and what's the exact rule? And hopefully go from there. Any questions? All right, great. Well, thank you, everybody. It was just a treat to see everybody today. Thank you for your support. More programs coming up soon. So we hope to see you then. Thank you. Bye-bye.